For judgment item number 1, WPC 11,860 of 2015 and batch of matters.
We've awarded 10 lakhs as compensation to the family of the deceased. We've given detailed directions on formulating a comprehensive action plan and taking disciplinary action against the doctors, health workers who were responsible for the death. And we've appreciated the work of the Orissa because they've prepared such a good report, which has helped us deliver a good judgment.
Lord, it may be uploaded today so that we can immediately communicate it to the government.
Correct.
Or your lordship may direct that this order may be communicated to the.
I've also said that. We've also said that.
Yes.
Yes.
By process. That is.
For judgment item number 2, WA 282 of 2019.
The writ appeal is allowed. We restored the earlier order.
For judgment item number 3, WPC 7052 of 2022.
Writ petition is allowed.
Obligement.
with the government counsel and Mr. Srikanth Naik, senior advocate.
Devasis Naik. He is-
No, I am holding for my learned senior who is sitting here.
Oh,
Please
okay.
can I go?
He-
My lords.
All right.
But he has some throat problem, in fact. I don't know if your lordship is immediately listed. He said 11 items total. So I have to individually make a chart, in fact. I could not do it yesterday night.
All right.
If your lordship fix a short date, if your lordship can take up the matter.
All right. Mr. S.P. Mishra and the senior counsel states that he'll prepare a chart to assist the court on the factual aspects and also a note of submissions
Not of submission.
before the next day.
10-3.
The counsel for the opposite parties are also permitted to do likewise. Then we'll have it in January.
My lords.
Any day, your lordship.
9th January.
My lords.
No, great.
Sir, can I want to make a mention from the list?
That interim order to continue.
Interim order to continue. Yes,
Great.
Mr. Mishra.
Lord, item number 90 of the list, today's list,
Hmm.
matter was to be listed for orders for bail matter. Your lordship remember, two matters were there. One your lordship disposed of. At the end, this matter your lordship asked to get instruction about the antecedent. But instead of that, though lordship is not there, so let it come tomorrow for orders of for bail matter. So far, the criminal appeal 84 of 2019 is concerned.
Sir, actually tomorrow we are having a special bench for this, correct?
So bail matter,
We'll have it tomorrow then. You want it tomorrow, right?
Yeah, it should be listed for orders matter. The IA matter should be listed for orders, not for hearing.
I see.
Along with criminal appeal number 372 of 18, which your lordship had allowed on the ground that he is already in 10 years. In fact, your lordship was going to allow this also, but my land friend took time to get any antecedent. Criminal appeal 372 of 18.
Correct. Criminal antecedents. That's right.
Yes. But wrongly it has been listed for hearing. And the 372 your lordship allowed on the ground that they are already in custody for about more than 9 years, which I submitted that my case is better when your lordship was about to allow.
No, so we can list it tomorrow.
Yes, ma'am, for orders.
Or
The IA matter
238 of 2019 in criminal appeal 84 of 2019. List tomorrow for that bench. All right.
much.
All right.
Can it come that 372 is necessary or not, ma'am?
Sorry?
372 of 18, which your lordship had allowed on the ground that they are in custody for more than 10 years.
That's all right. So that's the standard order. Now we are passing in so many matters. All right.
Supplementary list, old matter, item number 2.
None appears dismissed.
Old matter, item number 3.
One, this is audited. May 24. All right. None appears dismissed.
Item 3.
None appears dismissed.
Item number 4.
Non-filing of certified copy. For over 8 years now, certified copy is not being filed. This is not prosecution.
Item number 5.
None appears dismissed.
Item number 6.
None appears dismissed.
Item number 7.
May I please, your lordship? On behalf of Mr. Bose, may I permit to submit. This is a PL matter, my lord. The opposite party number 4 is a private party who is in forceful possession of over the government land. The around 200 families of scheduled caste has given a representative against the opposite party number 4. But till now, no action has been taken by the.
Are you sure this is a 2016 writ petition?
Yes, my lord.
How?
Till now,
See, this has not even come up once, sir.
No, on 8th November 2016.
it was
That's right. It simply said granted 2 weeks time to obtain
Yes,
instructions.
Yes, ma'am.
All right, you say if not already disposed of, the petitioner's representation, bracket annexure 1, shall be examined by the Collector Puri or Tahsildar,
Tahsildar maybe.
Kakatpur, and after notice to the petitioners as well as opposite party number, and after giving them a hearing, a reasoned order should be passed not later than 9 January 2023 and be made available to the parties within a week thereafter. The court clarifies it has not expressed any of the matters. All right.
Obliged, my lord.
Item number 8.
Nana, please discuss.
I'm in virtual mode, my lord.
Oh, I see. Yes, tell me.
My lord, this is the
Delays.
Kindly, I have read that. Kindly see the page 3 of my readability petition, paragraph 4, my lord. Paragraph 4, there I have written that if for sweeper, he has been suspended from his service. His service was terminated, but in course, he was allowed to engage an advocate first. But the appellant was not allowed to cross-examine the witnesses, and the appellant was not allowed to adduce any evidence. And my lord, I am the poor sweeper, and here his service has been terminated. My humble submission that he may be permitted to cross-examine the witness or adduce some evidence. After that, whatever permission they will give, they have.
Is there an interim order in the writ appeal?
No.
Over, sir.
My lord, now he is out of service.
What's the impugned order? What is there in the matter, sir? You tell us.
But that the PW1 who was for the affair, he himself was a PW2 is the victim. Both have adduced their evidence that the petitioner is not involved in kidnapping the PW2. Moreover, the PW2 is a married woman now, and he after his marriage, after her marriage, she is living happily with her husband. And the kidnapping is just moreover, whatever the incident that was not occurred in the due hour, and that is outside the police give the final report that there no such incident. But after that, the departmental inquiry, the service of the petitioner was taken up. Yes, inquiry, and I am allowed to cross-examine the witnesses like through an advocate. Because I am
Wait, sir. This is all impractical. Something that happened 30 years ago, 9 June 1993. Where's the question of calling witnesses now and cross-examining? It's all impractical.
After 4 years, the incident, after 4 years of the incident, the inquiry.
No, it's all impractical, sir. Not at all practical.
Then I want to place all the evidences which will be, if you will give me one chance, I will the evidences, I will appear before your honor and produce all the evidence. To hide that there is no evidence with regard to charge. Kindly see what is the charge. Charge that I have taken away the PW2 from the custody of her father. But the PW2 herself appearing with the court that she stated that I have not kidnapped her. And moreover, my lord, now she is married and staying with her husband.
Then just let it be, sir. No need to call all of them now for participating in all this.
Yes, sir.
Just let it be. Some things are best left where they are, instead of traumatizing everybody now. You see, the challenge in the present
What sweeper, my lord, what expectation?
doesn't mean that he picks up somebody's daughter and keeps her.
No, my lord, that's a totally incorrect fact. That's
Yes,
a
yes.
totally incorrect fact. That is
All
a
right.
evidence.
All right. The challenge in the present appeal is to an order dated 28th August 2017, passed by the learned single judge, dismissing writ petition civil 795/2008, filed by the petitioner. Questioning of the order dated 18th November 1993, passed by the Commandant, Central Industrial Security Force, (CISF), Discipline Authority -DA, inflicting the punishment of removal from service on the appellant who was working as a sweeper with the CISF. Paragraph. The charge against the appellant was that he took a daughter of another sweeper without informing him and kept her in his brother's house. And when the father came looking for his daughter, he started attacking him with deadly weapons, causing him a head injury. Full stop. Paragraph. A regular inquiry was conducted, during which the appellant was placed under suspension. Full stop. The inquiry officer found the charges proved, and this was accepted by the DA, who has imposed the punishment of removal from service. Paragraph. The order of the DA was confirmed by the appellate authority, (AA). A revision petition was also filed against the order of the AA, but that was rejected. Full stop. The charge against the appellant was that, being a married public servant himself, he kept the daughter of his co-employee in his house, and when questioned, assaulted the father of the daughter of the girl, which was unbecoming on the part of a public servant, and that too in a disciplined force like the CISF. Paragraph. Mr. Jena, learned counsel for the appellant, urged that an opportunity should be given to the appellant to again cross-examine those who had deposed in the inquiry against him. And therefore, the matter should go back to the stage of inquiry. Paragraph. The learned single judge has noted that there was no procedural infirmity in the inquiry conducted, and has also declared fear in the exercise of the powers of judicial review under Articles 226/227 of the Constitution, being satisfied that there was no violation of the principles of natural justice. Paragraph. The counsel to the appellant, during the course of his submissions, informed the court that the girl in question was now married and settled. Full stop. The incident is almost 30 years old. Full stop. At this stage, to require witnesses to again be produced in an inquiry just to enable the appellant to cross-examine them will not serve the ends of justice. Full stop. The court also is not inclined to interfere with the concurrent findings that procedural irregularity or violation of the principles of natural justice during the inquiry. Consequently, there is no merit in the writ appeal and it is dismissed as such. Delay control.
Item number 9.
Lord, these matters have become infructuous, man.
Infructuous, dismissed.
Item number 10.
None appears dismissed.
Item number 11.
None appears dismissed.
Item number 12.
My lord, I am for State Council School and Mass Department. This is related to age limit. In this case,
whom are you appealing for, sir?
My lord, this case has similar case has been already disposed of, item 12 and 17.
No. Whom are you appearing? Whom are you appearing for, sir?
School and Mass.
There is no one appearing for the appellant, sir. Not to worry then. None
My lord,
appears.
I have already similar cases disposed of, my lord. I have supplied the bench court manager.
All right, sir. All right. None appears.
Item 12 and 17. When item 12 and 17.
There is no case as the order dated 18 October 2022 in writ appeal number 488 of 2017, bracket Riti Snigdha Dash versus State of Orissa. The appeal is accordingly dismissed. Same order in
17.
17. All right.
Item number 13.
None appeals dismissed.
Item number 14.
None appeals.
May I seek for a small pass over, Miller?
All right, pass over.
Item number 15.
May it please your lordship, as per noting, my lord, I may be permitted to confine one player, my lord, which is my lord. Aside the input order dated 18/10/2017, passed in review number 338 by 2016 under Annexus 6, my lord. That is the review petition. The review petition was dismissed only on the ground of limitation, my lord. That limitation period was not intentional, my lord. Delay is, my lord, 590 days, which is not intentional.
Madam, please don't justify a 590-day delay.
My lord, my lord, university, whole university department is under construction, my lord.
No, that's
not there, my lord.
No, we're not inclined. Appeal is directed against.
High law stress could not be stressed out, my lord. That's why the limitation
All
is
right. All right. You say the appeal is directed against an order dated 9th November 2015, passed by the learned single judge. Declining to of an order dated 9th November 2015, passed by the learned single judge in writ petition civil 7055 of 2010. Paragraph. The reason for dismissal of the review petition was that it was delayed by 590 days. Paragraph. Counsel of the appellant seeks to convince this court the delay was bona fide and be reasons. Stop having examined the impugned order and having considered the submissions of learned counsel for the appellant, the court is not satisfied that the extraordinary delay of 620 days, of 590 days, in preferring the review petition was properly explained and required to be condoned. There is no error committed by the learned single judge in declining to entertain the review petition. It's accordingly, the appeal is dismissed. Yes.
Item number 16.
May I please your lordship? My lord, this is a matter relating to settlement of a motor accident victim before the motor accident claims tribunal. And in that tribunal, my lord, here in absence of
how is a writ appeal maintainable?
Writ appeal is filed against the order of the honorable single judge.
And what jurisdiction, sir?
My lord, and the writ application was filed before the honorable single judge, being aggrieved by.
Sir, how is a writ appeal maintainable?
Writ appeal is maintainable against the order of the honorable single judge because the section 19 subsection 5 of the Legal Services Authority Act was not followed during the Lok Adalat.
Sir, writ appeal, how is it maintainable? We're on the question of maintainability, not on merits.
Against the order of the honorable single judge, my lord.
Sir, his single judge exercised jurisdiction under Article 227.
Yes, my lord.
So how is a writ appeal maintainable? We withdraw this appeal to seek other remedies, sir. Counsel of the appellant seeks leave to withdraw the present appeal with liberty to seek other appropriate remedies available to the appellant in accordance with law. This post office withdrawn with liberty spirit.
Item number 18.
Yeah, memo is taken on record. Disposed of is withdrawn.
Item number 19.
None appears dismissed.
Item number 20.
My lord, I am there for the appellant, my lord. I may be permitted to appear in virtual mode, my lord.
Yes,
my lord, lordship, may kindly see page 62 is the impugned order, my lord. Here the entire issue is with regard to vacating the plot which is under the occupation of the respondent, my lord. We have filed a counter affidavit before the learned single judge, but the learned single judge, without taking consideration the government's taking the counter affidavit, my lord, the counsel for the would not remain present. That is a specific case. Kindly see page 62. Only basing upon the submission made by the petitioner that he has already vacated the plot in question, the learned single judge disposed of the writ application.
What
page
remained?
62, my lord.
Yeah, what remained once he's vacated the plot?
Our specific case is, my lord, he has not vacated. In fact, my lord, all his retirement dues are lying with us. We have made a undertaking that once he approaches us after vacating the plot, we'll, my lord, release all his retirement dues.
You file a review petition. If he is factually not vacated, you file a review petition.
Yes, review petition has been filed. Lordship may kindly see page 66, my lord. There also, my lord, the learned single judge, my lord, held that both the sides have been heard, but that's not a fact, my lord. Page 66.
No. Has he vacated or not? That's the question, sir.
My lord, he was in occupation of a plot and a quarter. He has vacated the quarter. He has not vacated the plot, my lord.
What is it? Not vacating the plot meaning what?
My lord, he was under occupation of a plot and a quarter, my lord. He has taken VRS in the meantime. He has vacated the quarter, but he has not vacated the plot, for which his retirement dues are still lying with us. Our specific case is, my lord, that once he vacates the plot in question, he
Sir,
can...
What you argued in your review petition before the single judge was not about vacating the plot. You seem to have said that there is a violation of natural justice. Heard.
Because I was not heard, my lord. Yes, my lord.
No. So if your case now is that his plot has not been vacated, then what is there to show he's not vacated the plot?
My lord, lordship may kindly see, my lord, counter affidavit, my lord. I have annexed the counter affidavit in my writ appeal, my lord. Lordship may kindly see page 18, my lord. Page 18, that is the specific avament I have taken in my counter affidavit, which has not been considered, my lord. Page 18, my lord, that starts with a paragraph it is pertinent to mention towards the middle portion, my lord. And
so this writ appeal has not even come up once in the last 4 years.
My lord, I am aware of that, my lord. Today the noting has come that the certified copy has not been filed. What I am praying, my lord, Lordship may grant me 2 weeks time, peremptory order may be passed, my lord. I'll file the certified copy, my lord.
No, but what is there to show that he's still occupying the plot? What plot has a gate in which he has locked or what?
No, my lord. Once he surrenders the plot, my lord, he has to sign a register.
Sir, how has he got? What is the form? Is it a vacant plot or what is it?
It's a vacant plot, my lord.
Vacant plot has a wall or a gate which he has locked or what is it?
It's a confined area, my lord, within a wall. He's occupying that area.
Why can't you file a suit to get him out?
My lord, the procedure, my lord, in Paradip Port Trust is, my lord, he has to get the NOC from the estate wing. That
no.
NOC
So you should institute proceedings at the Public Premises Act.
Yes, my lord.
Do that. You say if it is the case of the appellant that the respondent is still occupying a plot unauthorizedly, then it is open to the appellant to seek appropriate under the available statutes for that purpose. Full stop. The court sees no reason why it should interfere with the impugned orders of the learned single judge for that purpose. The writ appeal is dismissed. Yes.
Item number 21.
None appears dismissed.
Item number 22.
May I please, Your Lordship? I am on VC, my lord. I may permitted to appear on VC, my lord. My lord, here I have challenged Annexure 6. Am I audible, my lord?
Yes.
My lord, I am challenging Annexure 6, my lord. Your Lordship may kindly turn to page 36. The ordering portion is from 38 and 39. 39 is the main trust of the impugned order, my lord, whereby the order of the collector, Baleshwar, that an application under section 35 of the Consolidation of Holdings and Prevention of Land Act 1972 is not maintainable since the purchaser of the land is none else but the wife of a co-sharer. On that ground, the collector dismissed the case. But the Honorable Single Judge, without interpreting that, because the transfer has been made, he has set aside the order. Grievance. Your Lordship may kindly see section 34(2) of the Act, my lord. Section 34(2) says, my lord, no fragment shall be transferred except to a landowner of a contiguous chaka. My lord, section 34 says about prevention of temptation. One is not relevant, my lord, for my purpose. Two is important, my lord. no fragment shall be transferred except to a landowner of a contiguous chakra. So it says that only it can be transferred to a adjacent chakra owner, but not to an outsider. But here, the land is sold to the wife of a co-sharer.
Wife can't be an outsider, sir.
My lord, on that ground, the honorable single judge has
Correct. How is the wife an outsider? Wife of the co-sharer, how is she an outsider?
My lord, that is my. She cannot be an outsider. That is the finding of the collector in my favor. Accordingly, he dismissed the case. Your lordship may kindly see Annexure 6, my lord. And the first, your lordship may kindly see order of the collector, my lord. That is very clear.
Achha, this has already been admitted and notice is gone. What is the position?
Yes, my lord. Yes, my lord.
3 and 6, Lord.
So 3 and 6 have not been served. Opposite respondents 3 and 6 have not been served.
My lord, I will take fresh steps. My lord, these are not listed. So I will take my lord.
Respondents 3 and 6 have not yet been served. Fresh notice, returnable. 6th February.
Interim order to continue, my lord.
When was interim order passed?
It was
interim order. Interim order to continue. All right.
My lord.
Item number 23.
But the point for consideration here in this appeal is whether by virtue of a power of attorney and affidavit, title can be transferred from one person to other. Suraj Lamp case, Lordship knows that transfer is not a valid transfer. But this is what the point. Now, here the difficulty is one of the opposite parties. I had taken out notice in 2019.
Respondent 13. No such addressee.
That's right. That's the problem. Otherwise, I would have immediately placed it. That's the limited point.
Fresh notice. Now, no such addressee means
no such addressee means
there is no such person at all. Then you have to go for paper publication.
That is what I am required to do it.
Right. Counsel for the appellant, since the endorsement on the notice sent to respondent 13 has been is open quotation, no such addressee. Counsel for the appellant is permitted to.
May I just seek liberty from the Lordship? The respondents, in fact, they are appearing through Mr. Bhaskar Chandra Panda. If he can appear for also, rest of the opposite party is appearing.
Where is he? Where is Mr. Panda?
Can I serve a copy on him and see?
Correct. You see, today none appears on behalf of the contesting respondents. Bracket except respondent 13 who is yet to be served. Bracket. We'll stop Mr. Rathal on counsel the appellant informs that one Mr. Bhaskar Chandra Panda advocate in appearing for the other contesting respondents. Stop. He's permitted to say notice without process will be issued to Mr. Panda to appear in the next date.
Maybe a short date, my lord, so that sometime in the month of this month, my lord, 17, 18.
Or at 17th.
17th. Great.
All right.
Interim orders to continue.
Interim order to continue.
Item number 24.
Delay. 173 days. There's a delay of 173 days in filing the appeal.
Keeping the law open will become
not satisfactorily explained. Consequent loan, IA number 655, 2018 is dismissed. The appeal is accordingly dismissed. However, the question of law arising from the impugn order is left open for decision some other appropriate ways.
Item number 25.
None appears dismissed.
Item number 26.
None appears dismissed.
Item number 27.
May I please, your lords?
But sir, I am appealing on behalf of Mr. Pal. I'm for the respondent. I don't have the extra copy.
But the matter is what?
The appeal has been filed against the judgment of the Lord and single judge annexure 2 at page 25. Well, lordship may straightway move to page.
No, limitation disposed of for right.
Page 44. In the last line, As such, the registering authority cannot and could not have refused to make endorsement or correction in the certificate of registration because the financier has not renewed the trade certificate for doing its business in the state. But here, that has a serious impact on the state because all the financiers have not obtained trade certificate and their vehicles has been registered by the registering authority. And all the provisions has been quoted. Your Lordship kindly see.
Sir, this judgment is 17th August 2017.
My Lord.
And the judgment allows the writ petition filed by the respondent.
My Lord.
It directs you to make the endorsement.
Yes, that has been complied with.
But no. If it has been complied, not just for this respondent, for anybody.
Yes.
There's been no stay of the order, sir. So there's already you yourself complied with and you're following that regime now. So why change it? You say it is seen that the State Transport Department has complied with the order dated 17th August 2017, passed by the Learned Single Judge in Reproduction Civil 7544 of 2017. And endorsed the termination of hypothecation in the certificate of registration in accordance with Section 51 of the Motor Vehicles Act, Rules 60 and 61 of the Motor Vehicles Rules 1989. Full stop. The Learned Single Judge was of the view that, open quotation, the registering authority cannot refuse endorsement of hypothecation and cancellation thereof in the certificate of registration on the grounds not permissible in law, unquote. The said judgment has not been stayed by this court and has held the field for more than 4 years now. More than 5 years now. Full stop. In the circumstances, the court sees no reason why that status quo should be disturbed by interfering with the impugned order at this stage. Full stop. The court finds no reason to interfere. As the requirement for making the endorsement of hypothecation cancellation thereof in the certificate of registration is not connected to the renewal of trade certificate issued in favor of the financial. Stop. The writ appeal is accordingly dismissed.
Item number 28.
No instruction, my lord.
No instructions dismissed.
Item number 29.
29, my lord, delay of 2 months.
What's the matter about, sir?
Well, matter about regarding the appointment of Anganwadi worker.
Yes.
Well, the appellate authority passed the order. Recording a finding that yes, the original certificate was produced, but that was ineligible. And subsequently, he produced the original certificate before the appellate authority. And appellate authority, against that order of the appellate authority, the opposite party number 3 challenged before the Honorable Single Judge. Although earlier another proceeding, in that proceeding at the instance of the present appellant, well, the matter was remitted back to the sub-collector, being the appellate authority, to consider afresh and pass this order. And thereafter, the opposite party number 3 challenged the order of the appellate authority before this Honorable High Court on single bench. That is under Annexure 10. And the Honorable Single Judge, the writ application, recording a finding that
you could not produce it at the appellate stage.
Yes,
I produced it at the original stage itself.
Malad? Yes, Malad. But produced, that is the
when should you produce? When should you be permitted to produce?
But the fact is, the present appellant secures more marks and he has produced.
Documents have to be produced at the time of application, sir, not subsequently.
Malad, the single judge come to a conclusion that there is a clear provision in the guideline to produce original certificate at the time of application? No, my lord. There is no such provision under
Not
the
original.
guideline under Annexure 1, my lord.
No, it's not about original and copy. You did not produce anything.
No, that I had produced.
What?
That is also, that has been gone into by the appellate authority.
Yes.
That the finding. But this honorable single judge came to a conclusion that I did not produce the certificate, my lord.
Correct.
But my humble submission
That's
is
the only original, sir. What else?
yes,
We can't produce original.
original because it was a little bit affected by the white ants. There was illegible, and subsequently he submitted by bringing the duplicate. Both were compared by the appellate authority, and it is found that the which was time before the committee, my lord, that is correct. And accordingly allowed because the appellant secured a highest mark than the opposite party, no 3, my lord. And guideline does not envisage or clearly stipulate that yes, you have to make an application along with the original, my lord.
Please read page 51.
Page 51, my lord.
Para 5.
Had the Lord and Council for the parties gone across the relevant documents as recorded, as also the documents placed by the petitioner as well as the State Council, which has been taken on record. Undisputed fact that in pursuance to the advertisement, the petitioner along with the opposite party number 3 and other 5 candidates have participated in the selection process. 5 candidates were absent. Only 4 candidates have participated in the selection process along with the petitioner, as well as the opposite party number 3. Petitioner belongs to SCBC category, while the opposite party number 3, the present appellant, belongs to the SC category. The selection committee, after examining the documents as per the stipulation made in the notice inviting applications, has rejected the candidature of the opposite party number 3 on the ground that on the date of scrutiny, the original marks have been submitted by her. Hence, the selected the petitioner. Selection of the petitioner has been questioned by the opposite party number 3 by filing WPC number 763 of 2010. This court, while disposing of the writ petition, has given a liberty to the opposite party number 3 to approach before the appellate authority in terms of in terms thereof. An appeal has been filed wherein the selection of the petitioner has been reversed with a direction upon the CDPO to prepare a fresh merit list. This court has gone across the impugned order. Respective assessments of one and the other candidates as furnished by the London Additional Government Advocate, which is on record, has found that the original HSC mark sheet was not submitted by the opposite party, considering the provisions of Guideline 5/2007, which provide the original mark sheet certificate is to be produced at the time of verification of the document. The opposite party number 3 has not furnished such furnished original HSC mark sheet, which is substantiated from the communication issued by the CDPO Balikuda dated so and so to the ADM Jagatsinghpur, as contained in letter dated stating therein that the opposite party number 3 could not have produced her original HSC mark sheet on the plea that the said mark sheet was destroyed by white ants, and on the basis of that, in the marks column of the merit list at the time of accepting application forms along with the documents. It has been noted that opposite party number 3 has not submitted original mark sheet, which is mandatory condition as required in the guideline 2005-6, or submitted at the time of application. The petitioner therefore has been declared to be successful candidate since the candidature of opposite party number 3 was rejected on the ground of non-submission of original HSC mark sheet for its verification on the date of verification. She, however, taken a plea before the ADM that she had produced the original certificate, but it was not legible, and therefore she has made an application before the Board of Secondary Education.
You have been out of service now for 4 years.
Malat?
You have not joined the service, or you are
out of service.
I have to take instruction at present situation, but he had joined. He was discharging his duties. But today I could not be able to take the instruction whether in pursuance to this judgment, what development has taken place.
Sir,
but
virtually there is no stay granted by this court.
Malad. Malad, notice has been.
And the order set aside is of 2010.
Malad. But in pursuance to the order of the appellate authority, he was appointed. Present appellant was appointed and continuing in the.
No, after 2018, the impugned order is
18. After 18, I have to take instruction, but I have fairly submit. I could not.
You asked for stay, sir. If your client was not in service, you should have asked for stay. Only then she can continue in service.
Might be. I have to take instruction, on that whether he is continuing from 2018 or not.
The appellant wants to take instructions on whether the appellant continues to remain in service, despite the impugned judgment of the learned single judge.
As a copy may be served. Copy has not been
Copy of the appeal will be served on counsel for the statement. 2nd January.
Item number 30.
My lord, state is the appellant. There is a delay, but
244 days.
My lord, 44 days, but it's
244.
224. My lord, your lordship will
leave the question open, sir.
No, that is the. Just I will take 1 minute. What is the crux of the matter? There is a lease condition that the lessee cannot transfer the land to any third party without written permission of the lessor. Here is a case where admittedly he has transferred the land by way of registered sale deed, gift deed to a third party, and by virtue of that sale transactions, the learned single judge has said that the transferee can get title and the record of right can be corrected in his favor. That is the only
the question opens. The delay of 240 for this factor is explained. Accordingly, the IA is dismissed. Consequently, the writ appeal is dismissed. However, the question of law arising from the impugned order of the learned single judge is left open for consideration in some other appropriate case.
Item 31.
None appears dismissed.
Item number 32.
None appears dismissed.
Item number 33.
Item 33, no instruction.
No instructions dismissed.
4.
None appears dismissed.
Item number 35.
None appears dismissed.
Item number 36.
None appears dismissed.
Item number 37.
None appears dismissed.
Item number 38.
38. May I please, your lordship? My lord, petitioner before my lords is a school. Your lordship may kindly look at page 11, my lord. School is functioning since 1993, having about 2,260 students.
Yes.
I have given a sketch map, my lord, at page 11. The vacant land that your lordship is looking at, that is being utilized that day for a playground and other purpose of the school. Now the BMC, Bhubaneswar Municipal Corporation, is taking steps to, your lordship, convert it to a vending zone.
You've got representations made.
I have filed representations to all concerns, including BMC and the state authorities, my lord. That is at page 17 is the Secretary School Mass. Also, my lord, GA department. That is at lordship page 24.
Now, which is your governing department?
In fact, possibly this will be set. It will be, my lord, School and Mass. But GA department, they control the director state, they control the.
The petitioner's representations, bracket and 3, shall be considered by the Secretary GA department, and after notice to the petitioner as well as the other authorities, including Secretary School and Mass Education, the Bhubaneswar Municipal Corporation, and the Bhubaneswar Development Authority. A reasoned decision shall be rendered in writing within a period of 3 months thereafter. The decision shall be made available to the parties within a week of being delivered. The court clarifies that it is not expressed in even matter. Petition is disposed of.
Till then, my lord, I pray, let it not be.
Nothing's going to happen, sir.
Students are playing there. Play school is required.
Nobody's going to touch you.
No, I have stated, my lord, on 2.9, there was a, my lord, your lordship will look at page 11. Why I don't have insisted, my lord. On 2.9, in fact, the local councillor pays paragraph 7, my lord. Local councillor along with the corporator, other corporators and the mayor, they inaugurated the area and they will be starting for this. So, my lord, all the school students, 2,290 students are there. 7 buses.
But there is no formal transfer of this land to anybody.
My lord,
there is no formal transfer of this land to anyone, sir.
That's right. We have offered that we will pay the government whatever rate.
They have not transferred this land to anyone else. You have not mentioned that they have transferred this land to somebody else.
No, they have not, but they are going to establish a vending zone.
We don't know, sir. So
that I have indicated, my lord, they have already.
No, but that we don't know if there is a formal order for that. There's no such order enclosed to the petition. Let this happen, sir. Let their representations be considered. All right.
The lordship checklist, the status quo is on date, may not disturb.
No. Yes.
Item 39.
May I please, Your Lordship? I have already filed a memo for withdrawal of the case, my lord.
All right.
During pendency of the writ petition, appeal has been filed, my lord.
All right. We see counsel, the petitioner's memo is taken on record. The petition is disposed of, is withdrawn in terms thereof. Right.
Item number 40.
May it please, Your Lordship. Items page 63 on Form 148 notice was issued, madam.
Correct.
I have to take instruction because I have received a bunch of judgment. Just
all right. Mr. Chimanka appearing for the department seeks time for reply. You have not filed a reply also.
I filed the counter. They filed rejoinder.
No, not in this case. This is a new case.
No.
This is a new case.
There's no counter here.
This is a new case, man.
Achha, notice, Mr. Chimanka accepts notice on behalf of the Income Tax Department. Who is the General Electrical?
No, they are not relevant party.
I have not received the copy.
He appears and accepts
notice for page 118. Your lordships had passed an interim order in the earlier round.
Right.
Same notice.
No, but who are 3 and 4?
There is 18149 of 2021.
Respondents 3 and 4, what are they?
Your Lord, respondent number 3 and 4 is the person who had given 4 is your lordship can delete. I'll delete 4, not required.
At the old request of the
3 is the donor.
Mr. Parijal and senior counsel appearing for the appellant. Respondent number 4 is deleted from the array of parties. Then you say notice, he accepts notice for the department, that is opposite parties 1 and 2. Notice to opposite party number 3 returnable on the next date. By registered speed post, a tracking report be placed on record. When is that other matter coming up?
You know, that other matter is not listed as of now. Lordship can tag both the matters together.
You say
that is 18149 of 2021.
18149 of 2021. List along with that matter on 3rd January.
Lordship, please.
2023. Interim order. There will be no coercive step against the petitioner till the next date.
Lordship, please.
No, copy is not received. Let me supply.
I will supply extra copy.
All right.
No, copy is not received at all.
I will supply copy.
Supplementary list item 41.
None based.
Item number 42.
The petitioner here is a licensee. He is seeking relief of exemption of MGQ during closure period due to public objection. But the shop has been shifted. I just will like to show your lordship one line from page 16. In their inquiry report pertaining to shifting matter, para 3, your lordship will see inconvenience in doing business due to objection by nearby people. The excise authority they have reported. Lord Sakti Prasad Mahanti's case, K. Bina Patnaik's case, lordships have been pleased to refer the matter to the government. Should I give those orders to your lordship, ma'am?
This is 41. 41.
This is 42.
41 the con.
41 non-appears.
This
lordship have been pleased to refer the matter to the government.
Yes. This can be referred to the government for necessary.
All right. The petitioner's case shall be first considered by the secretary, is it?
Right, Lord Secretary.
To the government excise department. For that purpose, the copy of the present petition shall be entrusted to the said authority within 2 weeks. Stop. The said authority will, after hearing the petitioner, pass an appropriate order on the prayers of the petitioner. Within a period of 3 months from today, and in event not later than 2nd January 2023, the order be made available to the petitioner within a week thereafter. If aggrieved, it will be open to the petitioner to seek appropriate remedies in accordance with law. The court clarifies it is not expressed in any matter.
If I can request your lordship, the government while considering will take this into consideration. No? Just one observation that will do, man.
That is, that they will do.
That just one.
Pass a reasoned order, taking into account the orders already passed by this court in various similar matters. All right.
Great.
For orders item 43.
None appears dismissed.
Item number 44.
Okay, none appears dismissed.
Item number 45.
None appears dismissed.
Item number 46.
My lord, the order under review dated the 10th May 2011 is under Annex 1 at page number 11. The delay of only 41 days.
Yes.
And copies are served and delay of 41 days. And that because of the order was received only after 15 days, and that is a took some time, and the delay was only 41 days in filing the review application.
All right. Tell us what the.
My lord, only question of law, that is only on 2 counts this review petition was filed. That that beyond the pleadings, that is not in the counter, that BSRB was required to conduct this examination, which was observed by the honorable court. That because at that time BSRB was not there, only IBPS was conducting the case and question papers were coming from IBPS. That was not in the pleadings. That is beyond the pleadings. And the second one is that is
at this stage we should be interviewing. Leave the question open. Is the court is not inclined to recall the order dated 10th May 2011 passed by this court, disposing of writ petition civil 13115 of 2009 and 12802 of 2000, sorry, and 13115 and 12302 of 2009. Sorry, 12802 of 2009. Paragraph in the last 11 years, over 11 years, there has been no stay of the order which is sought to be reviewed. Consequently, while leaving the questions of law, if any, arising from the said order open for consideration in some other case, the court declines to interfere. The review petition is accordingly dismissed. Corrected writ petitions. All right. All right.
Item 47.
None appears dismissed.
Item number 48.
None appears dismissed.
Item number 49.
None appears dismissed.
Item number 50.
None appears dismissed.
Item number 51.
None appears dismissed.
Item number 52.
I am for the opposite party bank, your lordship, in this
All
matter.
right. None appears dismissed. All right.
Obliged.
Item number 53.
None appears dismissed.
Item number 54.
In item 54, your lordship, a CAPL which is arising out of the first appeal, your lordship, as your lordship has already transferred first appeal to the district judge, your lordship, let this matter be also adjudicated by the district judge for the your lordship.
Yeah, it will automatically get adjudicated.
But it is there, your lordship, so let it transfer to the district judge.
No, what's the delay here?
Yes, your lordship.
If the first appeal is dismissed for default by this court, district judge cannot restore it. That is the difficulty you will face. District judge cannot restore the first appeal if the appeal is
You know the number of days delay?
Yes, Your Lordship. But what has happened, Your Lordship, on 2008?
No, just tell us the delay.
5 years, Your Lordship. But
1,579 days.
But also I can explain, Your Lordship, why it has happened. There was a preemptory order in 2008, Your Lordship, with regard to filing of the name of the respondents as well as the compulsory documents which are to be filed. But there was an interim order in 2000 that we have to deposit in cash security of rupees 12 lakhs, which was renewed by the respondents from year to year, Your Lordship. In 2014, it was renewed, and subsequently the matter came out in 2013. So in 2013, when the matter was came up for renewal, we came to know about the dismissal of the first appeal. We have a preemptory order.
There's a delay, huge delay of 1579 days in filing this application for restoration. The reasons for the delay are not satisfactorily explained, and the court is not convinced with those reasons. Accordingly, MC number 111 of 2013 is dismissed. Consequently,
at least Your Lordship observe that we have already deposited part payment. Let it be deducted from the principal amount.
Better not say all that.
It's already on record, Your Lordship.
Anyway, better not in this application. We won't say all that. Yes, this FA, it's just disposed of already. Yeah.
Item number 55.
None appears dismissed.
The contempt may be in 55.
It's a disposed of. Contempt's already been disposed of.
Item number
I am for state appellant. This has been filed for restoration of appeal, same appeal. This has been, my lord, I kindly see the order dated 19/3/2014 in the writ appeal number 385/12. My lord, directed to payment of cost ₹2,000 towards cost to the respondent one within 2 weeks, telling with the writ appeal shall stand dismissed without further reference to the bench. Admittedly, same appeal has been filed delay, but delay has been stated when on 19/3/2014, my lord directed to payment cost. On 20th, we have communicated the state respondent for payment of for deposit and cost. This has been received by the on 5/4/2014. On 22nd 7/2014, Director Second prepared a check in favor of the counsel for the
this CMAPL itself. The delay application is filed 2 years later.
No, my lord.
Yes. The delay application, Ms. Case 210, is filed only on 19th August 2016.
My lord. CMAPL has been filed earlier.
That's all right, but the delay, unless a delay is filed, it will relate back to that date only, sir.
But that was a defect due to.
That's what you can't cure. You didn't cure the defect for 1.5 years.
My lord.
There's already a delay of 231 days in filing the CMAPL. Worse still, the application for continuation of delay was not even filed with the CMAPL. It was filed on 19th August 2016, 2 years after the CMAPL was filed. The court is not satisfied with the explanation for the delay on both counts. Consequently, Ms. Case number 210 of 2016 is dismissed. Consequently, CMAPL 403 of 2014 is dismissed. Yes.
Item 57.
57 is the same type of the writ was dismissed, but there is no delay. I think very less.
12 years.
12 years.
There's a delay of 12 years in filing.
No, my lord, it cannot be 12 years. Oh, I see. Yes.
Delay of 12 years in filing this application for restoration. The reasons for the delay is not satisfactorily explained. Consequently, MC number 156 of 2014 is dismissed. CMAPL is dismissed.
Item 58.
No. Delay.
It is a matter case. The matter was dismissed on 4/7.
195 days delay.
My lord, it was previous conducted by previous layer. I have given the face power.
the matter cannot be disposed of in the meanwhile. But in the miscase, he has mentioned that he has an impression that it will come in the court. But my lord, the petitioner is a lady.
All right, sir. There's a delay of 195 days, is it? Which is not satisfactory.
She will harass a lot.
No.
So I humbly pray that maybe restore.
Not at this stage, sir. Already 89 years are over.
My lord, the previous lawyer cannot taken up the matter by his pursuit. And I have gave the fresh file. And it was in the list on May. And court number 1, it is not reached. So considering the predicament of the lady, will suffer. I humble pray before your lordship that may be restored.
All right. Delay is not satisfactorily explained. Consequently,
my lord, in the miscase he has mentioned.
The same appeal is dismissed.
My lord, I humble
Item 59.
Sorry. Yes.
Item number 59.
None appeal is dismissed.
Petitioner file man, petitioner under order 5 rule 26 man for a publication of notice in newspaper man.
What's the matter about, sir? Tell us.
Mr. N.N. Mahapatra, the conducting advocate, he just appear. Mr. N.N. Mahapatra is the conducting advocate man.
You call him. Kindly call him. All right. Pass over.
Well, no, she is out of question, man.
No, sir. We're not going to adjourn this matter for these kind of reasons. Then tell us what the case is about.
No, the petitioner for notice again. A notice was issued by the Honorable Court, but it is same has not been solved, man. This is the problem, man. You knowingly avoided the notice, man.
You see, the direction issued by this court on 7/12/2021 to the council to place and record the amended memo of parties reflecting the LRs of Sheikh Kalimuddin has still not been complied despite an opportunity having granted on 23rd February 2022. The court does not propose to grant any further indulgence in this case. The petition is dismissed. Yes.
Item number 60. Item 60, sir.
Pass over.
In item number 61,
yes,
I am appearing, sir, from Delhi, and
there are several defects, Mr. Agarwal.
Only defect, they say that there should be a notice of 2 months, but there is a provision that if it is an urgency.
I think you're appearing in 61, Mr. Agarwal.
Yes, I am appearing in 61.
Okay. Because 60, we called out 60 is passed over. Okay, 61.
Number 6 in item number 60.
It's passed over. Item 61.
Yes, Your Lordship. In fact, if Your Lordship will see page 22, sir, one of the schools visited in district Puri was flooded, washed away during the cyclone 2018, page 22, and it was washed away.
Mr. Agarwal, what happens is because of the rules of PIL here in Delhi, Orissa High Court,
yes,
you're first supposed to make a representation to the authorities, and if they fail to act in a representation, then the PIL is permitted.
I have made a representation.
When is that? Where is that, sir?
That is page
email.
50,
by email.
Page 56, and it was addressed to.
First consider your representation.
Page 56.
Actually, this representation is addressed to me.
Yes, and copy was sent to the government.
All right, we'll ask them to first deal with this, sir.
Yes.
A comprehensive representation.
Let them file a representation to the collector directly.
Let him treat this itself. You have a copy of the petition.
No, the read petition copy is also not served on.
Actually, you have to serve a copy of the petition also, sir.
I will give today itself. I have served them a copy. Receipt is in the registry, but I will give you another copy. No problem. Today itself, I will give. My learned from me is
all right. At the outset, Mr. Agarwal states that a copy of the writ petition will be served on Mr. D.K. Manti, Learned Additional Advocate General, Government Advocate, today itself. Full stop. Annexure P2. He states that Annexure P2 has been, copies of Annexure P2 have been sent to the Secretary, School and Mass Education by email.
Yes. Page 72 is the receipt. It shows.
Yes.
Oh, it's School and Mass Education.
Yes.
Sent to Chief Minister, Education Minister, and then all authorities.
All right. The Secretary, School and Mass Education is directed to examine the said representation bracket and Annexure P2. And
Sir, I would request you to please ask them to file a status, because this is a general problem in.
No, let them. You see, let them hear you in person. Let them address it, and if they fail to do it, then we'll take it up, sir. The School and Mass Education Secretary is directed to give Mr. Agarwal a hearing, examine the and pass appropriate orders thereon, not later than 12th December 2022. The decision of the Secretary SME shall be made available to the petitioner within a week thereafter.
Is it possible, Your Lordship may say that let them take necessary steps, whatever is required, because drinking water is not there.
That's right. You say examine and take whatever steps and direct whatever steps are required to be taken. Full stop. The petitioner is not satisfied with the outcome of the said proceedings. It will be open to the petitioner to seek appropriate remedies in accordance with law. Right. The petition is disposed of. All right.
They will decide by 6th December.
By 12th December, sir. So one month away. Yeah.
My lord, copy may not be served on me. That part may be deleted because it is dealing with school and mass education.
Copy may be served to the school mass.
So,
I am on the status.
So,
I am on status.
they have received the
copy. No, I have not been served. I may be served a copy.
So instead of Mr. Mohanty, you say Mr. Padjoshi?
Yes, my lord. I am
Standing Council SNME cell. What is your email address, sir?
No, my school mass department cell.
All right.
Department cell.
All right. Because it has already been sent. The copy has already been sent by email to the secretary.
Yes, my lord. That may be, but our cell is got in contact.
No, you have to get in touch with them, sir. Then. All right.
Let a copy be served.
So either you give your personal email. If you say no, he has to have it on school education. He's already served.
The school mass education cell in Advocate General Office.
My lord,
is part of the AG office.
His mobile number may be noted in the order. I will contact him.
Yes, that is rather that is better.
To me, it is very important matter. In fact, I have seen children in whatever conditions they were studying.
Let department be served. Secretary.
Yeah.
Anyway, they've already been served, sir.
Yes, madam.
Yes. All right. All right. You just put Mr. Padjoshi's name, not Mr. Mohanty. Right.
Item 62.
Copy not been solved.
My lords,
Copy not been solved.
I'll share the copy by tomorrow, my lords.
Is it a fresh matter or?
Fresh matter.
All right. Mr. Beura undertakes to serve a copy of the petition by tomorrow on council with the department. Modify. What is this? What is this prayer, sir?
My lords, this is challenging the first appellate order because tribunal is not.
But look at your prayer, sir. It's so carelessly drafted. Should you not say quash annexure 4? What is this prayer? No. What is this? Modify, reconsider order? Which order? You better draft a proper prayer, sir. You say, counsel the petitioner undertakes to
amend. I'll amend.
Undertakes to amend the prayer clause to correctly reflect the reliefs being sought. Thereafter, he will serve a copy of the petition on the counsel of the department. This be done within a period of 2 weeks from today. List thereafter.
Item number 63.
Maybe pardon 2 weeks time to remove the defects, Your Lordships.
All right. Defects be removed within 2 weeks. List thereafter.
Item 64.
Lordship may kindly grant me 7 working days.
All right.
To remove the
Defects be removed within 7 working days. List thereafter. All right.
Item 65.
65, my lord, I've already served copies on my learned friend, my lords. Here, my lord, the matter is relating to payment under the Biswa subsection. Under the SVL DRS 3, my lord, they have determined the amount. And due to difficulties, my lord, the amount could not be paid. And the lordships recently had in high-tech multiplex private limited, my lord, they have held that manually this amount has to be paid to them. And they will take appropriate actions, my lord, as per the scheme, my lords.
Your Lordship, I may pardon, my lord. There is beneficiary scheme, the date has already been over. There is no acceptance in the technical mode. Your Lordship, I humbly pray, my lord, 1 week time is given so that the mode of payment, if it is, my lord,
in that
1
case,
week, they will solve all the purpose. They may not come to the court.
No objection. Let it come after 1 week, because in the other case, Your Lordship, Your Lordship have allowed manual payment, my lords.
All right. You said the request of Mr. Satpathy, who appears for the department. List on.
Your Lordship, directly issue notice so that
notice Mr. Satpathy accepts notice and 6 time for instructions. Add his request list on 23rd November.
23rd.
Your Lordship.
Item number 66.
This is regarding cancellation of GST registration. I have annexed annexure.
As per earlier order of this honorable.
We pass the same order.
Yes.
All right. Which is annexure?
Annexure 1.
Annexure 1. Same order as an annexure 1. All right. Disposed of.
Right. Item 67.
May I not take to 1 week time to rectify the defects, my lord?
All right. Defects be cured within a week. List there. Right.
My application.
Great.
Item number 68.
Yes, my lord. I am in the virtual mode, my lord. And here the petitioner is the assessee of GST, licensee of GST. And she had one GST license which was cancelled due to non-filing of returns consecutively for 6 months. On 4th December 2019.
This must also be covered by our order.
No, my lord, here he's asking for payment of 10,000 because of non-payment of non-filing of the returns, my lord. So, my lord, your lordship, my lord, he is not able to pay that amount. Therefore, my lord, his license has been restored in 2019, cancelled.
He's made a representation. Maybe you should consider that.
That may be considered, but fact, my lord.
Yeah. Not a representation. He has to file a proper application, no? Mr. Ratha, you have to file a proper application, not a representation.
But they told that it is the representation is according to them.
No. There is a form. There's a application. You have to file it in that form. It's an online application for revocation of the cancellation under section 30.
30, yes.
My lord, already it is revoked.
That's right. For cancellation of that revocation, you have to file an application.
It has already been. It is now active, my lord. The grievance is that he is challenging that the penal proceeding because non-payment, because he delays the filing of return, he has been directed to pay. He has to pay the fees, late fee. That is the issue, my lord. That is under the statute that is there, my lord.
Correct.
It cannot be waived.
Correct.
So,
subsequent charges.
your lordship, may I request, my lordship, issue notice so that I'll return back next week. And extra copy may sought so that it can be, if it is helpful to petitioner because
Praying also for revocation of cancellation of RC also.
Yes, both the issues are kindly.
All right, you see notice, Mr. Satpathy accepts notice and seeks time for instructions.
Yes.
Same 23rd November.
Item 69.
I may be pardoned, my lord. I am on virtual mode. My lord, I am unwell and I am having very acute back problem.
All right. Counsel for the petitioner is stated to be unwell. Defects be cured in the meanwhile. Within 2 weeks, you see list thereafter.
Item number 70.
May I please, Your Lordships?
Yes.
Your Lordships, in this matter, already discharge certificate has been issued to me by at page 18, Annex 4, Your Lordships.
Yes.
But after that, they have issued the assessment order that is imbued with this. Every entire tax amount has been deposited by Annexure 3, and they have also issued the order of acceptance where they have stated that all the proceedings are dropped, Your Lordships. After dropping the proceeding, they have issued the order.
Notice. He accepts notice on behalf of the opposite parties. Reply be filed within 4 weeks. Rejoinder for the next date. Till the next, no coercive action shall be taken against the petitioner. List on 2nd January.
Item 71.
71, Your Lordships, already have removed the defects, and only my representation to the NHI is pending by Annexure 3, Your Lordships.
All right. The petitioner's representation at Annexure 3. What is that to show this was delivered?
They have deposited TDS amount. NHI has deposited TDS amount in a wrong GST, Your Lordships. And they have admitted that, and they have
No. Is there a postal receipt or something to show you have sent this representation?
Is it, there is a endorsement also at page 17, Your Lordships. Page 17, that is, they have received.
Where?
Oh, sorry. No. Pursuant to that, they have replied, Annexure 4.
Oh, I see. The same may be rectified to show true and fair view of accounts. What does that mean?
Yes, that means they have deposited in a wrong account. My TDS has been deposited in a wrong account instead of my GST number. Because I am the JV, but they have deposited the TDS amount in the personal GST of one of the partners. And that they have admitted, and they have taken steps as per Annexure 4, but they have not taken steps till date. Only that.
It's better than notice. It is returnable.
Only my small prayer before is that they may be directed to take steps within a stipulated time, because representation is still with them.
All right. It is seen that in reply to the representations made with the petitioner, NHI informed the petitioner's advocate on 15th January 2021.
It is their advocate, Your Lordships.
To their own advocate, is it?
Yes.
Or they have informed their advocate regarding rectification of the wrong deposit of TDS. Stop. Yet no action appears to have been taken. Stop. Paragraph. Directions issued to NHI to rectify the wrong deposit as indicated in the letter dated 15/1/2021 on or before 12th December 2022. A copy of this order be sent to the opposite party number 2. Was it 3?
Yes, right. 3.
Opposite party number 3?
Yes, 2 and 3. Your Lordships.
All right, 2 and 3. The petition is disposed of.
Okay.
Item 72.
So I've already served a copy on my learned friend for 72 and 73 minutes. Here my appeal has been dismissed under the GST Act, my lords. Since the tribunal is not there.
Yes, since there is no second appellate tribunal, the court is constrained to entertain the present petition. Say notice, he accepts notice. Reply be filed within 4 weeks, rejoined up for the next date.
And your lordships in those directions have allowed me to pay 10% and some cases 20 also. 10% of the remaining amount of tax.
Here you have already.
I have already paid 10% during the pendency of my first appeal.
All right. Counsel for the petitioner informs the court that he's already paid 10% of the tax during the pendency of the first appeal. Full stop. Consequently, upon the petitioner depositing a further 10% of the remaining tax within 4 weeks, no coercive steps should be taken against the petitioner during the pendency of the present petition. The highest disposed of.
73 similar orders may be possible.
Same. And list on 3rd January.
Item number 74.
Lordships, item number 74 and item number 75, Lordship, both the
infractions in this post of.
Item number 76.
Memo. Yeah. Said memo is taken in record, dismiss is withdrawn.
Item 77.
Not 77, 78, 79. This is a lottery matter, Lord. Has become...
All because of Navin Kumar. Up to 80. No,
80 is different. 80
all right.
Relief grant has been relief sought for has been granted, Lord, by the government.
All right. In 80, you say infractious and disposed of.
77, 78, 79 is lottery matter.
Right.
Item 81.
81, I will take instruction in the similar type of cases are pending also.
And who's for the petitioner?
Item number 81.
Defects will be removed in 2 weeks time.
Okay. Defects will be removed within 2 weeks, list thereafter.
Item number 82.
May I please?
Yes.
Your Lordship's permission, Lord, we have already filed a consolidated appeal memo by incorporating the question in page 5. Question IV. And this issue is not covered by the Supreme Court judgment. Whether on the fact and circumstance case, the IT is correct in holding and in effect confirm the CITL decision that in fact and circumstance case, the expenditure bond is a revenue expenditure, which in reality is a capital expenditure for the purpose of section 35, more specifically under 2C clause IV of the said provision law. If a Lordship see that the observation in the assessment order, page 16, then I will take your Lordship to appellate order. Turning page 16.
16.
Yes.
Yes.
Issue of expenditure incurred on the issue of bond.
Yes.
The assessee incurred expenditure on the issue of 16.5% energy bond. These bonds are issued on private placement basis. That is important, private placement basis, to collect fund for the expansion of program. The total expense of bond rupees so and the same is by the assessee over a period 7 year, financial 17-18. There is no basis of such amortization as per ratio decision of Supreme Court in state of Punjab. Industrial Corporation.
Correct. It is a capital expenditure, sir.
It is a capital expenditure. So he has been allowed tribunal as a revenue expenditure. You should see the finding of the tribunal in page 33.
What's the tax effect, sir?
Tax effect is not
60 lakhs 48,000.
You're there for the assessee.
I'm there for this.
You'll also see page 19, annexure 2, appeal order. 21.
Should we admit it then?
The Lordship may admit it, I will file a reply to it.
All right. Admit the following question of law is framed for consideration. Then take from only question. 5I.
Yes, Lordship.
You see, list for final hearing. Both parties are permitted to file the written notes of arguments before the next date. List for final hearing on 10th January.
Item number 80.
No, sorry, not 10th, sir. 1 minute. 11th January.
Item number 83.
And dismissed.
Item number 84.
Appearing for the respondent, I filed my wakalat. And I've also filed the compliance affidavit where the orders of the tribunal has already been worked out for the income commissioner exemption.
Oh, I see.
Your Lordship may kindly see them.
All right.
And there was no stay throughout.
Correct.
Well, the Supreme Court judgment is there. So let us
work it out, we'll leave it open, sir.
Supreme Noble Milord with respect applies prospectively. Or you would see the last line of the Supreme Court's order that will apply prospectively. Noble education.
Oh,
19th January.
New Noble Educational Society laws that has to apply prospectively. And here the tribunal's order has been worked out.
Mr. R.P. Kara, learned counsel appearing for the respondent, has filed a memo of his appearance today, which is taken on record. Paragraph, he has also placed on record an order passed on 25th September 2018 under section 10 bracket 23 capital C bracket Roman small 6 of the Tax Act 1961 by the Commissioner of Income Tax bracket exemptions bracket Hyderabad, giving effect to the judgment of the tribunal in the present case. Paragraph, consequently leaving the question of law urged by the revenue open for decision in some other appropriate case. The appeal is disposed of.
The Supreme Court judgment is there. That judgment is there.
Your Lordship may see the last page.
All right.
It will apply prospectively because the Lordships have said notes.
All right, then we leave it, sir.
Yeah.
Right.
And the appellant here, my lord, is the person who has given me the exemption. He has worked it out. Commissioner exemption. All right. Great obligement.
Item 85.
For respondent.
Yes.
Lordship has already admitted the question of law.
Okay.
Question B, my lord. I appeal memo page 10. On the fact and circumstance case, the learned IT justified to deleting addition made by your towards.
No, we just issued notice. We're not admitted it yet.
No, just issued notice.
Should be admitted, sir. Mr. Panda.
Actually, this court has already passed the order examining the reason that has been given by tribunal in para number 3, number 3 of the order of the High Court. And this is the successive order passed by the tribunal in series of cases, because first they applied to ASCA Cooperative Central Bank, and they have again applied to all other banks, including me. Therefore, this being the consistent decision of the tribunal, there should not be interference to this particular matter, because it will cause unnecessary jeopardy to the functioning of the cooperative banks.
No, there's no stay or anything, sir. It's only a question of law that has to be examined.
No, this particular law has already been examined by the Ahmedabad, Gujarat High Court, following the judgment of the Supreme Court, very categorically saying that whatever is not income recognized should not be taxed. Here is the case, an NPA, whether it shall be taxed or not. NPA is a asset which is unproductive, and even RBI has also issued a direction. The CBDT has already issued a circular that these particular interests which are not collected for 3 years should not be taxed. And there is an overriding provision in section 45Q of the RBI Act that these are all the things NPA interest should not be taxed at all. So in view of that, my prayer is that this particular matter may be actually having been decided by the High Court. There is no point again to allow them.
Not by our High Court, by some other High Court.
No, our High Court has passed an order in IPA number 77 on 15/3/2022. This is for the second time, same SSC, second time. And not second time, this was in the appeal of 2012-13. This High Court has already dismissed revenue appeal. And again, they have agitated the matter for 2000.
Where are these orders you're referring to, sir? Where are the orders?
The tribunal's order is page 12.
No. High Court's order.
I have filed a memo, and in that memo, I have enclosed that. High Court order is 15/3/22. And it has come out in cause list also. Our own High Court order.
Then it can be dismissed.
But there, my lord, the second question, your lordship, kindly have a glance. Whether 45Q of the RBI Act and 140 Act would be to no role to pay, because my lord, here the Act itself says to no to the scheduled bank, my lord, non-scheduled bank. Your lordship see the 45.
No, it is not unscheduled bank. It is a cooperative bank. It is not
cooperative bank inserted in the section, your lordship see 45. We kindly have a glance, my lord.
No, but we have declined to interfere with that earlier ASCA.
Yes.
Just see the order in 15 March.
In consistency, your lordship hold that.
Yes. So same. You see, in view of the dismissal of ITA number 77 of 2018, filed by the department against the same SSC, by an order dated 15 March 2022 of this court, the court declines to entertain the present appeal, which raises identical questions of law. The Appeal is accordingly dismissed. Right.
My lordship.
For admission item 86.
Not pressed, my lord. 86, not pressed.
That's not pressed. Right.
Item number 87.
This is Mangala Jodi.
Right.
Yes.
Where is Mr. Ashish Mishra?
Petitioner was supposed to file rejoinder to
I know. The petitioner is not yet. I just wanted you to examine one thing.
Yes.
Can there be any operation of boats without noise, without pollution?
Lordship, that I am for the intervener, Lordship, with your permission, with your Lordship. Boat it is costly. It is the sound now the present boat are generating. That is the allegation of the petitioner because of the excess sound of the boats.
Not only sound, because all these are diesel boats.
Lordship, obvious there is no other.
The fumes are black. Very black fumes are coming out.
Lordship, what that is coming out, Lordship, that is why your Lordship has directed that to be main channel to be connected to that fishing hamlet through which the main channel, the fishing hamlet people, they can access to Chilka, Lordship. Because from the fishing hamlet.
I'm only on this. Whether boats, you can have battery operated boats.
Operated. That is what also I was thinking. That it could be
battery or solar operated boats.
Lordship, it is an innovative thought what your Lordship has developed. It is to be adopted not only in Chilka, across because at the present rate the ecosystem is now deteriorating. It is not only in Chilka,
something we permit, something it will affect.
Your Lordship, the other addressing your Lordship, the other they addressing the man-animal conflict in Madhya Pradesh, Lordship. We are hearing your Lordship's view on that.
Right.
Lordship, what do you propose for this motorboat, if it will be stopped at the present stage, Lordship, it will be cause a lot of inconvenience to the
that we are aware of
fishing hamlet people.
No, that report, last time we read that report, which is why
Lordship, just your Lordship have a view, 30 years before, there are no machine boat. People are using that kind of
manual.
In a manual process, and also they are using that in local language, they called it a tole. It is a huge
sail.
Through that air will populate.
Correct, sail boats.
Yeah. So that was there. So Lordship,
nowadays people will not accept that.
No, Lordship. Few people they are doing it. Those who don't have this access to the machine boat at the beach area, they are.
You examine that also. See, as long as we can avoid motor and fumes, diesel or kerosene, I think they're using kerosene for.
Yes, Lordship.
As we can avoid these two things, then there's no problem in permitting the boats.
May I pray one thing to your Lordship? Your Lordship may pass a judicial order on this and ask me to file affidavit on that point.
Right.
On solar use or any kind of any other.
Whether it is possible, the government will file an affidavit.
All right. You see, Mr. Ashish Mishra, who was to file an affidavit,
rejoinder
affidavit is not appearing today. Paragraph. The court would like the state government to explore the possibility of either solar operated or battery operated boats or of sailboats in place of boats which are run on motor engines, which can cause both noise and pollution. Full stop. An affidavit in this regard be filed by the state before the next date. We'll have it in December itself. The season is still on. I think 19th December. 19th December.
Lordship, my appearance on behalf of the intervener applicant.
All right. Yeah, definitely. All right.
Item number 88.
My lord, kindly permitted to withdraw.
Counsel, the petitioner seeks leave to withdraw this petition. Dismiss this withdraw. All right.
Item number 89.
Today we have filed
Your
the
Lordship,
counter.
today I have received the counter affidavit. I may be permitted some time to file my
All
return.
right. Rejoinder be filed before the next date. Is there an interim order?
Yes, Your Lordship. Interim order is there, but it
Interim order
just
to
says
continue. List on 12th December. 12 January, sorry. 12 January.
obliged, Your Lordship.
Password. Supplementary list passed over matter item number 14.
Mr. Rao.
May it please your lordship.
Yes, yes.
The writ appeal is directed against the order passed by the Honorable Single Judge.
Yes.
In disposing of because what has happened, I was a tenant and I filed an application before the Tahsildar for declaring that the land is non-resumable under section 36A of the OLR Act, Orissa Land Reforms Act, and that was allowed. The original tenant, the collector has in an application under section 59(1) reviewed that order, saying that it should be inquired further by the Tahsildar.
But actually, you have succeeded, except that the single judge has ordered a remand.
Yes. Single judge, I have raised two grounds. Number one is that there was a compliance of section rule 27B. Therefore, there was no error by the Tahsildar. And the second one is the proceeding was initiated against a dead person by the revisional authority. So, Honorable Single Judge found that the one point I have succeeded so far as 27B is concerned, rule 27B is concerned. So far, the second point is concerned, Honorable Single Judge, instead of holding that the proceeding has been initiated against a dead person, has held that since there was notice to the LRs, and therefore that has to be inquired further. My submission before our lordships is initiation of the proceeding against a dead person is different from after the proceeding is initiated, somebody dies and the substitution is take place.
In effect, it will be the same, Mr. Rao. In effect, it will be the same thing. On remand, it's only the LRs who will be heard.
Only LRs will be heard. That's all right. But once it is against a dead person, the entire proceeding has to be dismissed simply.
No. Then it's only a formality, sir. Then notice will go to the LRs now again when they can't be prevented from initiating fresh proceedings. The fresh proceedings will be against the LRs.
Against the LRs, but
so it's net result is the same.
No. Fresh proceedings means it will be barred by time. They can't do it.
No. It will be a continuation. Now that we have continuation of the earlier proceedings.
Against a dead proceeding, if dead person proceeding is initiated, that is a nullity and there cannot be a continuation of that. Anyways, I leave it to you.
You say
because I personally I felt that this is a matter where I have succeeded in the matter on two grounds. But then still Honorable Single Judge says that it should be inquired.
Correct.
Because the death is admittedly before the proceeding has been initiated.
All right. You say the challenge to the impugned order dated 23rd March 2018 by the present appellants is only that since the proceedings were initiated against a dead person, the matter should not have been remanded to the Tahsildar for a adjudication by the learned single judge. Paragraph, the court finds that in any event, if the proceedings were to commence afresh, it would commence against the LRs of the person stated to be dead at the initial stage. And therefore, the net result would be again proceedings afresh before the Tahsildar will stop in that view of the matter, while reserving the right of the appellants to raise all pleas available to them in accordance with law in the proceedings before the Tahsildar. The court declines to interfere. The
Honorable Single Judge directed me to appear on 9th April 2018 before the learned Tahsildar. Now your lordship may fix up another case.
No, but are you sure that the proceedings are still pending there?
No, I am to appear along with this judgment.
No, there was no stay granted here. Are the proceedings still pending before the Tahsildar?
Today morning, I was contacting the local lawyer. He said that Tahsildar has not given any notice yet.
All right. You say the date for the appellants to appear before the Tahsildar is now fixed as 5th December. A copy of the order be sent to the Tahsildar in question. Right.
Pastor matter item number 60.
Just add a line. The Rao states on instructions that the proceedings for the Tahsildar are still pending. And then you add this.
Item number 60.
None appears despite a pass over dismissed.